this in a few years.
You surely can.
Good afternoon. My name is Ford Little. I appreciate the opportunity to appear this afternoon on behalf of plaintiff appellant Anderson Pordwalls. For the reasons set forth in Anderson's principal and reply briefs, as well as those I will briefly address this afternoon, Anderson respectfully requests that this court reverse the Sevier County Chancery Court's final judgment finding that plaintiff appellant Anderson had not exhausted its remedies against defendant general contractor Matthew Lippum, thereby dismissing Anderson's claim for unjust enrichment against the defendant homeowner, Gilbert Clark, for lack of a ripe claim, and that this court remand this case back to the trial court, ordering that the trial court enter a judgment consistent with the findings of the special master in this case. As this court is aware, based on its prior rulings and that of the Tennessee Supreme Court, the most significant requirement in a claim for unjust enrichment is that the enrichment to the defendant is unjust, and a party receiving a benefit desired by him under circumstances rendering it inequitable to retain it without making compensation must do so. This construction case differs from some of the construction cases that you may have heard previously. We do have a situation where a subcontractor, Anderson Pordwalls, a small family-owned subcontractor based out of Morristown, been in business for about 30 years, is properly licensed. It entered into a contract with a general contractor, Mr. Lippum. And we do have a situation where not only do we have a
written contract or oral contract?
It was an oral contract, but it was confirmed by a written invoice, Your Honor, for $61,026. So there's a breach contract claim where there was against the general contractor. Then there's an unjust enrichment claim against the homeowner. In this case, it was a vacation home based out in Sevier County. But when we filed the lawsuit, unlike so often you have when you have a construction case, we understood that and we asserted that the Mr. Clark did not or had not paid the general contractor for our scope of work. And in fact, that bore itself out, as you saw in the special master's report and the court's opinion. The facts demonstrated that. As this court is aware, for years in Sevier County, Chancellor Fogarty would refer cases to a special master. In this case, we had Special Master Scott Reams, who was agreed to by the parties, a respected, experienced trial attorney out of Morristown. Mr. Reams specifically held in his special master's report regarding the unjust enrichment claim against Mr. Clark, all the elements were satisfied. He also said and or ruled that there is no admissible evidence to establish that the homeowner, Gilbert Clark, in paying his loan to BB&T, paid for the labor and or materials furnished by the subcontractor, my client, Anderson Pordwalls. Special Master Reams weighed the injustice of allowing defendant Clark to retain the benefits conferred by the subcontractor Anderson in light of the landowner's payment of a third party for the provider services as explored in the Pascal's case. He concluded that it was distinguished from the Pascal's case because he said there is no evidence that there were any payments by Mr. Clark for the services rendered by Mr. Anderson, or pardon me, by Anderson Pordwalls.
Mr. Little, let me interrupt you and ask you this. What do we do with the testimony from Mr. Clark that he made a payment of around $62,000 that he said was for the basement, and then he said it had to have been because that was the only thing that had been done at that point?
So the problem with Mr. Clark's testimony, and as this court knows better than anyone, the trier of fact will evaluate the credibility of someone testifying. There was repeated testimony by Mr. Clark that he didn't know what work was being performed. In fact, he didn't have anything to do with the $61,000 payment. When we asked him about Anderson Pordwall's work, despite his attempt to testify to the contrary, I asked him, you don't know what that is Anderson Portwall's scope of work was then, because you weren't involved with it, correct? He said, that is correct. This is on volume 4, page 126 in his testimony. I also asked him, in fact, you didn't have a role in the process to check and see what work was being done, inspected, completed, and the proper amount to be paid, because you simply relied on the bank and the inspector. He says, yes, and relied on the contractor. He wasn't involved in the process. In fact, despite his efforts to testify that, because of the timing and it was approximately that amount, he admitted that the only invoice that he had anything to do with was approximately $60,000 invoice later in the project that dealt with electrical and plumbing and those type of things, which was in the fall, that is, I think, September, not back in the time frame when my client did its work. Moreover, what we learned was, and I think what Mr. Reams realized was that because the number was a little similar, he was trying to track that to or relate that to the work. But the reality was Anderson Portwall's scope of work changed. And even Anderson Portwall's didn't know the amount of its invoice until a couple weeks after that alleged payment that wire was going to be made. And so my client didn't even introduce their invoice or submit its invoice until after that particular time frame of that approval. And so we don't believe that when you look at the overall testimony, including the most important part of the testimony, the cross-examination, and Mr. Reams evaluating that testimony, that there's any evidence of the payment to my client. And in fact, there was admission that Anderson finished its work. Anderson had no defective work, which we normally see as a cross-claim or a counterclaim. Anderson had not been paid. Everybody admits Anderson has not been paid. And there's no dispute that Mr. Clark received the benefit. Moreover, as you probably saw in the special master's report or in the record, Mr. Anderson contacted Mr. Clark before the project was over and said, I haven't been paid. Can you please check with the general contractor? And I even sent Mr. Clark a letter saying, we have not been paid, the $61,000. And after Mr. Anderson contacted Mr. Clark and I wrote Mr. Clark still paid over $80,000 in bills to the general contractor. So there's clearly monies available to pay Anderson even after this was brought to Mr. Clark's attention.
What about, Mr. Little, the argument that there is no unjust enrichment because Mr. Clark did not retain any benefit? In other words, he paid the full price for the construction of the home, which included the basement work. So it's not like he double dipped. It's not like he got the house without ever paying for the basement. He just paid it to Gillum, whatever the guy was.
Gilbert, to Matthew Lipham.
And Lipham never paid Anderson.
That's the argument that the defendant has asserted in this case, but it's not supported by the record. There's one reference in special master report says it appears that Creekside completed the project and that Clark paid Creekside the contract price. But if you look at the testimony or the findings of Special Master Reams, he says he finds there's no admissible evidence to establish that Clark had made the payment in more than one position. Moreover, remember, if you look at the appellee's brief, pages 41 and 58, they cite two references as a basis for that argument, Your Honor. One is testimony by Mr. Clark, which, as we know, Mr. Clark didn't know what was occurring. And number two, Exhibit 42, which Mr. Clark, if you look at our brief, including our reply brief, Mr. Clark said, well, I rely on Exhibit 42, which came from the bank, which demonstrates that it's paid in full. Exhibit 42 doesn't demonstrate that. If you look at Trial Exhibit 42, it says, and I asked him, or his lawyer asked him, so what does the document represent? He says it shows a zero balance. But then when I cross-examined him, he looked at it and I made him acknowledge that if you look at the actual trial exhibit that he says he signed to conclude the loan, the totals on it show the original amount was $381,910. The remaining balance on Exhibit 42 shows a remaining balance of $274,670. Moreover, if you look at the line items and you compare the line items in that same Exhibit 42, what it acknowledges is that there's still work for footings, foundation, and basement that are still owed to my client, Anderson Pordwall. So you're correct, there's the allegation or the statement and testimony that Mr. Clark made that, I paid the full contract price. But the actual findings by the special master and the actual testimony on cross-examination, including their own Exhibit 42, demonstrate otherwise.
Okay. Thank you, sir. You have time for your rebuttal.
Thank you, Your Honor.
Yes, sir.
May it please the court. My name is Donald Vowell. I represent Gilbert Clark, one of the appellees here. As counsel said, we've got a cause of action for unjust enrichment. I'd like to talk about two things in particular. First, we obviously support the dismissal without prejudice for lack of exhaustion of remedies. Second, I'd like to talk about whether the case should be dismissed with prejudice. So as for exhaustion of remedies, you don't prove, this is the law of Tennessee, you don't prove exhaustion of remedies by just making a bare allegation that action against the defendant would be futile. You have to provide a factual basis to support the allegation. You have to prove it just like anything else. So what is the evidence here? Well, Mr. Anderson testified that he tried to collect the money for a very long time. As I'll get to later, he didn't even know this guy's address. He couldn't have tried very hard. But on top of that, he learned that there were several complaints against him from people that he owes money. So he says, I do not expect to get any of it. That sounds like a bare allegation. So no proof that he filed bankruptcy or, anything. So I don't think they have proved a factual basis for exhaustion of remedies.
Mr. Val, what would you say is the measure of proof that would satisfy that standard?
I don't know. It would depend on the facts of the case. Bankruptcy would be one good,
But if they weren't bankrupt, but yet they couldn't locate the person they were trying to get the money from?
Oh, if you couldn't locate him, I think they've had the address the whole time. We've been sending him all the papers in this appeal. But you could, somehow, just like you prove anything else, prove they're broke or they're destitute or whatever. But there was just, all we have here is the record.
Your client, Clark, he was aware this money was owed, and it's my understanding he even contacted Liplin himself regarding this money, and he was supposedly assured by him that it would be paid, and he continued to let it go on?
Well, it's a matter of who continued to let it go on. He didn't. He paid Mr. Lipham in full. And I don't know of any rule anywhere that a homeowner who's building a house is the one responsible for paying the subcontractors. I've never heard of that. There's lien laws, but there's no, as far as I know, there's no law that the homeowner himself has to earmark all of his payments for a specific contractor or make sure, or subcontractor, or make sure they're all paid. A lot of times the homeowner just writes one check at the end. I've heard of those cases. House on Main Street, paid in full. And the contractor is the one responsible for paying the subcontractors, not the homeowner. And the other side has not cited any law to the effect that the contractor somehow has a duty to hunt down and pay all the subcontractors. He took the word of the this guy, Mr. Lipham, hired Mr. Anderson to be the subcontractor, or Anderson poured walls. That's the privity of contract. And so they must have That's how the relationship was started. It's not Mr. Clark's fault that Mr. Anderson got hired, and that Mr. Anderson didn't check up on his contracting party. And that's another part of the argument that I'll get to. But he did nothing to see if his general contractor was solvent. He did nothing. He just ran up the credit, and as he just said, didn't even render an invoice for a long time, a verbal contract, just hoping, I guess, that he would be paid. So I hope that addresses the question. If I'm okay. So, but now, there were two general contractors. Segueing to the second general contractor, you have Mr. Lippum, who allegedly had several complaints. That was the thing, several complaints against him. But you also had Newell Homes, who had the building permit, and there was no evidence of any complaints against Newell Homes. So both general contractors, I don't think this is controversial, are jointly and severally liable for everything, anything and everything owed to the subcontractor. So it was a joint venture, according to the complaint. It said it about 4 or 5 times. And the complaint said that Newell Homes was vicariously liable for everything that Lippum did. And I think that's true. But Anderson Pordwall settled for $11,000 from Newell Homes.
That's the confidential settlement?
It was confidential. It's not anymore. It wasn't easy to get that agreement in the record, but that amount in the record. But we did, and Chancellor Fogarty agreed that it should be in the record, and he put it in the record, and so it's here. So $11,000, that's peanuts. $62,000 claim. It's not explained anywhere in the record why they let him off the hook for 11. No evidence that it was a reasonable settlement. It's just what they did. So they didn't go after Mr. Newell for the $62,000, but instead they're coming after Mr. Clark for it. He didn't have no contract, obviously, with this subcontractor. So now, but as I said, much better to dismiss with prejudice. And so I think we have a preponderance of the evidence that the homeowner paid the full contract price, as the court mentioned a little earlier. I happen to have the special master's report. It does use the word appears. Courts do that sometimes. It appears, but it appears that Creekside completed the project, and Clark paid Creekside the contract price. So if we're going to parse the language of the report, you could say appears, and obviously Creekside did complete the project. It appears that way, and they did. And Clark paid Creekside the contract price. So counsel said he wanted to do something consistent with the special master. The special master said the contract price was paid in full. And it was. It was a $278,000 contract, and the bank paid $274,000. And Mr. Clark paid some things himself. So that's preponderance of the evidence, and the special master found it, so it's done. Its contract price is paid in full. So I don't think he's unjustly enriched in any way. He's not getting a windfall. As the court said, if he has to pay again, he'll be paying twice for the foundation, because obviously paying the contract price in full includes paying for the foundation. So now, we already talked about this a little bit, this idea that somehow he hasn't proved that he paid for the basement. I find that to be a very curious argument. As far as I know, as I mentioned, there's no requirement for a homeowner to somehow earmark every time he makes a payment, which half the time, they don't even know who the subcontractors are. They have no idea. He doesn't know where the contractor's getting the bricks and the lumber. He knows he's getting them from somewhere, but he doesn't have to keep up with all that and write on write a lot of separate checks. Oh, this check should be used to pay for the bricks. That's just not the way contracts work. If a homeowner had to do all that and had to know all that stuff, there'd be no point in having a general contractor. So I'm going to add two details. We already said one, paying the full contract price would necessarily include paying for the basement. And obviously the foundation is the first thing to be built. Council said something like, well, Mr. Clark didn't know what was being done. Well, he doesn't have to know. The bank is out there doing inspections and the thing was built. He does know that if the argument is, how did Mr. Clark didn't know the foundation was built? He knew. I mean, he made the payment. He made the payment on the $62,000 on April 19th, 2018. This is Exhibit 36. That's the day, $62,000 some odd dollars. That's the day before Mr. Anderson finished the job. And it was the only thing that was built at the time. Mr. Clark was out there walking on the foundation. I mean, if you have to prove that you knew the foundation was built, I mean, I don't know why you'd have to prove that, but he was there. So as far as if the homeowner has to prove that he made a payment specifically for the every aspect of the job, and you don't have to do that, but if somehow you did, I think they proved it. It was $62,000. The invoice from the late arriving invoice from Mr. Anderson's company was $62,000. So the final major point I want to mention, in any event, you don't recover for unjust enrichment if you are responsible for your own detrimental position. That's Tennessee. We cited those cases in the brief. If you're the author of your own misfortune. So I think we have a preponderance of the evidence of the following facts. And it's Mr. Anderson's own testimony that's undisputed, so I'm pretty sure it's a preponderance. He discussed the job with this guy while they were drinking at the Roadhouse. He didn't get his address. He didn't ask him if he had a contractor's license. He didn't do a credit check. He didn't get a deposit. He didn't get a signed contract. He didn't get any drawings. The job turns out to be bigger than he thought. Nothing in writing other than text messages. And he couldn't even send him the invoice because he didn't know his address. Didn't even have an email address to send it to. And he says he thinks he read it to him over the phone. But somehow he thinks that Mr. Clark should be responsible for paying him. So I think the preponderance of the evidence is that he is responsible for his own detrimental position. The council mentions that the special master held that there was no admissible evidence that he paid for the basement. The chancellor did not adopt that finding. The special master said something like that, but he also said that he had paid the contract in full. The special master seemed to be under this misimpression that it seems to be perpetuated here today, that you have to prove every element, that the contractor has to earmark or the homeowner has to earmark every payment. I don't know where the special master got that idea, if that's what he was thinking, but that is not the law. And there's no reason for such a law. Mention that, and then last thing I'll mention is this 42. Got it right here. It's an interesting kind of exhibit. The main thing you get out of the exhibit is the amount that the bank paid. We know the loan is $274,670, nearly the same as the contract price. But this thing, it is when the contract was 0% complete. It says it right here, 0%. There were no inspections done. First inspection, all zeros.
This is an exhibit that's in the record.
Yes, sir.
Okay, go
42. And there were no draws. Draws to date, zeros all the way down. So I don't know what this thing is, but it doesn't have much to do with what was done out there in the end. This is maybe I don't know what it's for, but it is 0%. It doesn't have a date on it that I can find. So what it does, it shows the amount of that the bank was going to pay. And they did, as Mr. Clark testified, and it's not contested that he paid it. Paid in full. Thank you very much.
Thank you. Yes, sir.
Let me address two or three of the items that were asked of opposing counsel. Number one, I would ask you to look back at our brief, because the only evidence, contrary to the argument by Mr. Clark, that the contract was paid in full is Exhibit 42. He relied on it. If you look at Volume 4, pages 101 through 102, he says that's the basis for me demonstrating to Special Master Reams that I paid this full contract price. It does not demonstrate that. In fact, it demonstrates quite the opposite. Secondly, this argument about a preponderance of evidence demonstrates a basis for this court to flip and to dismiss the case in its entirety. That argument was never raised in the trial court or in any exception to the Special Master's report. The first time it's been made is here. And as I understand it, the same thing with the Newell Holmes argument. That has never been raised before the briefing in this case. And so I believe in this case, the court's case Chadwell versus Knox County, 980 Southwest 2nd 378, this court has indicated it's well settled that issues not raised at trial are not appropriate to be raised on appeal. The third item that I'd like to address is the question asked by Judge Davis. And you asked the question, what's the measure of proof when you're dealing with an exhaustion of remedies? There are two or three cases that talk about this. Number one is the Window Gallery of Knoxville versus Davis case, which is this court's case. And in that case, it was a subcontractor situation just like this. But what this court says at that point was that just this general argument that we've exhausted our claims is not enough. In that situation, they got or obtained or tried to obtain summary judgment against the owner, but they did nothing with regard to the general contractor. We're different here. We have a default judgment against the general contractor. In the Las Pumas Concrete versus Harmon Hospitality case, a middle section case, 2021, the Court of Appeals allowed a concrete subcontractor to recover against the building owner for unjust enrichment when the contract subcontractor had only successfully obtained a default judgment against the general contractor. So like this case, the Court of Appeals allowed the subcontractor to pursue a claim for unjust enrichment against the owner. Moreover, in the Freeman Industries versus Eastman Chemical case, 172 Southwest 3rd 512, it likewise differs than this case, because in that case what the court said was bare allegations of exhaustion of remedies is not enough. You have to do something to try to, in effect, go after the general contractor. In our case, we went through the process of obtaining the default judgment against the general contractor who's never appeared. Moreover, I'd like to point out that The arguments that are being made on behalf of the owner, Gilbert Clark, are based on his testimony. And what we heard in opposing counsel's argument before you today was, well, he's not required to go out there and do anything. He doesn't know what's going on. An owner's not ever expected to do that. But that's exactly what he did during the trial. He tried to testify about all kinds of facts. He tried to testify about what work was completed, by whom and when, and who should be paid. And when you look at the cross-examination and his admissions, as far as when I cross-examined him with his prior deposition testimony, what he admitted was he didn't know anything about any of that was going on. He talked about, oh, I saw the basement, I've got pictures. There were no pictures that were introduced. He talked about an engineer architect evaluating, or inspector. He didn't introduce that. The evidence that he introduced, and it's the reason I believe Special Master Reams ruled and said, I have no findings that there was any payment, no admissible evidence, was that when he was cross-examined, he admitted, I don't know. Despite his efforts during direct to try to say, oh, I know this, that, and the other. If he truly wanted to prove these things, which he had an opportunity to do in a full-blown trial, he could have called the bank inspector or the banking rep or the general contractor or anybody else to say this was what was going on. He didn't do that. And so the point I would make to this court is this. We're not like, I just filed a case and there's a motion to dismiss, and we're saying you shouldn't let Mr. Little subcontractor go after the owner because he needs to, in effect, exhaust the remedies against the general contractor. We've tried this case over 4 years. All the evidence is there before you. And the special master, and I disagree, that I believe the final judgment did incorporate the special master's report. If you look at the introduction as indicated in our brief, the special master said, after weighing the credibility, ruling everything, I specifically find that there's no admissible evidence of payment to the general contractor for Anderson's work. So we would ask that the court not make us do this over again, but look at the record and determine what's fair and equitable in this particular situation. Thank you very much.
Thank you. I want to thank both of the attorneys for your presentation. Your case has now been submitted to the court for resolution.